Australian Video Retailers Association Limited and Warner Home Video Proprietary Limited saw two parties go head to head in terms of how copyright and reproduction was dealt with when it came to DVD technology. Ultimately, all the questions asked surrounded how copyright would exist on digital platforms. The first question asked by the courts was, when playing a DVD disc, would data stored within the RAM be seen or constitute a reproduction under or a copy under Section 10 of the Copyright Act? The first thing the courts asked was, what is a copy of a film? Under Section 10 of the Act, a copy of a film is an article and thing in which the visual images or sounds comprising of the cinematograph film or motion picture are embodied. Under Section 21(6), such an article is embodied if it is in a readable form. Sounds or images are taken to be embodied where they are capable of being reproduced from an article or thing under Section 24 of the Copyright Act. So when we play a DVD and the DVD player is taking in that memory to actually give us the information of what the film constitutes of, is it being reproduced? The court said no. Justice Emmett said, the ephemeral embodiment of the tiny fractions of visual images and sounds that comprise a cinematograph film or motion picture sequentially does not constitute the act of making a copy of the motion picture or cinematographic film within the meaning of Section 86A of the Copyright Act. The mere fact that over a period of time, being the time taken to actually watch the movie, that tiny parts are sequentially stored within the RAM of the DVD player, it does not mean that the cinematographic film is being embodied in such a device, and thus there is no reproduction. The second holding by the court is where we see a bit more of the commerciality of the agreement in respect to the intellectual property owned by Warner examined by the courts. Pursuant to Section 31(1)(d), copyright in relation to computer programs includes the exclusive rights to enter into a commercial rental arrangement in respects of those programs, except under Section 31, subsection 5, for entering into a commercial rental arrangement where the programs are not the essential object of the rental. The first thing the courts discussed in seeing whether or not there was an essential object was that they made clear that it was about the purpose of the arrangement, not the subject matter. In this case, while the subject matter being the computer programs which allow us to watch and view these films that Warner owns were essential to subject matter, the purpose of why we entered in arrangements to either buy or rent these DVDs was definitely not to do with this software. Therefore, the essential object exception was not met, and when the Australian video retailers were renting out or selling these videos, they were selling the video contained on the DVDs and not the software program. The third question and holding that was made by the courts examined the interpretation of material form under Section 10 of the Copyright Act. The issue here was whether or not the read-only memory and the random access memory storage in computational devices will actually reproduce the content of a film in a material form. The courts held not ordinarily. They said the definition of a material form in the Copyright Act under Section 10 is far-reaching and covers not only the ROM and the RAM, but also all other types of storage to be developed in the future. Whether or not this will be a reproduction of a computer program in material form will depend upon the particular circumstances. That will entail an examination of the particular device on whose storage is under consideration. But ordinarily, this will not be the case. Therefore, a person who plays a DVD disc on either a DVD player or a personal computer does not ordinarily reproduce in a material form the whole or substantial part of relevant computer programs. This case raised some interesting questions around copying and data and things of that nature in terms of digital, and paved the way for the future of IP law in terms of digital consumer materials. Thank you for listening.